Have you ever been pulled over and wondered, wait, did I even do anything wrong? Or maybe you've seen someone stopped by police and thought, can they really do that? That question, what police can and can't do before arresting you, starts with one legal idea: reasonable suspicion. Reasonable suspicion is the lowest legal standard in our justice system. It's the point where an officer can briefly stop or question someone, not because they know a crime happened, but because there are specific facts that make them think one might be happening. It's a lower bar than probable cause, but still requires something real. A hunch, it's not enough. A feeling, a gut feeling, not enough. There has to be facts that the officer can point to, something they saw, heard, or observed that would make a reasonable person suspicious too. So let's give an example. Let's say it's late at night, a car drifts across the center line a few times. Well, that alone can make an officer reasonably suspect the driver might be impaired, tired, or distracted. Now, if the officer doesn't find evidence of a crime, well, they have to let you go. So for example, if they don't smell alcohol on your breath, they don't see bloodshot, watery eyes, they don't hear slurred speech, well, then they have to let you go because there's no other evidence of any crime, namely in this situation, DUI. So now let's give another example. An officer sees someone pacing in front of a closed store late at night, looking in windows, tugging on the door handle. That's not proof of a crime in and of itself, but it's reasonable to suspect that a possible burglary could be happening right then and there. And the officer can stop, ask questions, and do a quick pat down for weapons. But they can't search bags, phones, they can't search your car without a higher standard called probable cause. So what does reasonable really mean? Well, it means that another trained officer looking at the same facts would likely draw the same conclusion. It's not about perfection, it's about logic and experience. And the key phrase that courts use is specific and articulable facts. So that's a fancy lawyer term, right? It means that the officer must be able to explain what made them suspicious in words, not just feelings. If they can't describe those facts later in court, the stop might be ruled illegal, and anything that the police found after that stop or after that search could be thrown out and completely dismissed or suppressed as fruit of the poisonous tree. What are some things that the police can do when they have reasonable suspicion? They can stop you briefly to ask questions. They can request identification. They can do a limited pat down, a frisk, if they believe you might be armed or have drugs on you. What they can't do under reasonable suspicion is go through your car, go into your house, go through your phone, arrest you, and for all those other things, they need much more evidence. They need probable cause. Now, here's how this plays out every single day in Florida. Let's say you're driving through Fort Lauderdale and a police officer spots your car rolling through a stop sign, then drifting. Well, that's enough for reasonable suspicion. They can pull you over, they can ask questions. But if an officer stops you just because your car looked out of place in a certain neighborhood, that's not reasonable suspicion. That's a hunch, and it violates your constitutional rights. The idea behind reasonable suspicion, it's balance. It gives police just enough authority to check out suspicious behavior without giving them full power to arrest anyone they want. It's like a safety valve between privacy and protection. And without this step, police would need full proof to even ask questions, which could slow down real-life investigations. And I get it, police jobs, it's hard. It's hard to be a police officer sometimes. But if the bar were too low, then officers could stop anyone for anything, and our forefathers said no to that. And that's why, when they ratified the Constitution, they insisted that we had the Bill of Rights, namely the Fourth Amendment in there. Police often confuse reasonable suspicion with probable cause. So here's the easiest way to tell them apart. Reasonable suspicion is, I think something might be going on. Probable cause, I have evidence something definitely happened. Reasonable suspicion allows a quick stop. Probable cause allows an arrest. So think of it like fishing. Reasonable suspicion lets police cast out a line. They can check on and see what's going on. Probable cause means they've caught something real. They got a fish. They can reel it in and take it to court. If you ever get stopped by police, knowing this standard protects you. If they can't explain why they stopped you, well, that's a big red flag. And your attorney can later challenge that stop in court. We can't swoop in right in the situation and tell the police officer can't arrest you. I wish we had that power, but we can always analyze it later and possibly get your case dismissed or the evidence thrown out in court. And if a judge agrees that the officer didn't have reasonable suspicion, then any evidence gathered might be suppressed. That's why good defense lawyers always ask, what facts did the officers have before you were stopped? Because if the foundation is weak, the entire case falls apart. So here's the bottom line. Reasonable suspicion is about giving officers a small window to act. but it's also about protecting your right not to be stopped for any reason. It's the very first step on the pyramid, and everything that happens next builds on top of it. But what happens when the suspicion turns into something more? When officers think they have enough proof to arrest you or search your car? That's when we move up the pyramid to the next level, probable cause. And in the next video, I'm going to break down what probable cause really means and how it can make or break your case.